Hello, my name's Debra Allison and I work for the Office of the Public Guardian in Falkirk, although our remit covers the whole of Scotland, and I'm the Deputy Public Guardian for Scotland, and today I'm going to tell you all about powers of attorney. Well, first of all, introduce the conversation when it's a comfortable time and occasion to do so. It doesn't need to be a formal meeting, you don't have to produce paperwork, etc. An opportunity, for example, could arise when maybe talking about a will, or perhaps you've done your own power of attorney, see the benefits, and can speak informally to someone about how it might help them at some point in the future. It could be when you're getting together for an occasion and there might be a quiet moment aside when you could bring it up in conversation. It doesn't have to be daunting, it doesn't have to be scary. Thousands of people each year in Scotland do go ahead and make their powers of attorney, and it benefits them in the future. You might want to introduce conversation by asking your loved one what they would want to happen in the event that something happened to them and weren't able to look after their affairs. Who would they choose to do that? And it might be helpful that for them to know that nobody has any legal authority just to step in and automatically start acting when you become incapable. However, having a power of attorney does give you that legal authority to act. I would also emphasise, and it's maybe a bit of a myth buster, is that a will is not the same as a power of attorney. A will is for when you're no longer here, while having a power of attorney is to help you in the here and now. Another thing, a power of attorney won't tempt fate. Once it's made and registered with the Office of the Public Guardian, it can be put away in a drawer or whenever, just as a sort of safety net in case it might be needed at some point in the future. Another point I would add is that your next of kin, so husband, wife, son, daughter, whomever that might be, doesn't have any automatic authority to step in and act for you if you're not able to do so for yourself. However, having a power of attorney in place would give them appropriate legal authority. The first thing to know about granting a power of attorney is that you need to have capacity to do so. So you need to know what you're doing, and you also need to be aged 16 years or over. Most people approach their solicitor to make their power of attorney for them. You'd want to have a wee think beforehand about who you would want to act for you and what powers you would wish them to have. This would also be a good opportunity to perhaps write down for the benefit of your attorneys what your wishes and preferences are. You might think your attorney knows what you would want, but they might not. And by providing them with this additional information about how you would wish your wishes and preferences to be recognised will really help them with their decision making in future. For example, in my own power of attorney, I wrote a letter to my attorneys explaining what I would want to happen in certain circumstances, down to things like I would wish to have flowers around me, and I'm sure I mentioned something about red wine as well. So it sort of personalises things for you. You've got the list of powers in your power of attorney document, but this just enhances that, so your attorneys are in a better position to make decisions for you because it's based on your own wishes. Your solicitor will charge a fee, although in certain circumstances legal aid may be available. Different solicitors have different fee structures, so you maybe want to do a wee bit of shopping around and find out more first of all. You don't have to go to your solicitor, however, there are other options available. For example, some companies provide power of attorney templates online, and other professionals offer power of attorney services, and some charities are also able to assist in this regard. It is straightforward to do your power of attorney, and a solicitor, should you employ one, will give you all the advice and guidance that you might need. Once the power of attorney is in place, it can be put away and be used whenever it's appropriate to do so. You can grant your power of attorney to anyone of your choosing. The only stipulation is that they need to be over the age of 16. It could be a relative, a friend, a professional person such as a solicitor, but it's up to you. You're in control of that decision. I think most importantly, however, whomever you choose, it should be somebody that you trust. because you're giving them a lot of power. They're effectively stepping into your shoes and acting for you. So it needs to be somebody you trust to act appropriately and in concert with your wishes and feelings, and always to your benefit. You can have one attorney, you can have two attorneys, or even more, and they can act jointly, or if you stipulate, jointly and severally alongside. You might choose to appoint one person to look after the financial side and another person to look after personal welfare matters and healthcare. It's absolutely up to you. You can also appoint substitute attorneys who would step in if your main attorney was no longer able to act, for example, if they passed away or resigned their own position. So there's lots of options, but the important thing is to sit down and really think what you want to happen. It's your decision. The main difference between a power of attorney and a guardianship order is that a power of attorney is granted by someone while they still have capacity. A guardianship, on the other hand, could apply where a person has lost capacity and they don't have a power of attorney in place. So that means that they have no one available to act for them in terms of financial and property affairs or personal welfare matters. A guardianship order is applied for via the court, so it's very much a court process, and there's a lot involved with that. For example, a solicitor needs to prepare what is called a summary application, so it can be quite detailed because it sets out all the circumstances why you need a guardian, etc. But importantly, there also has to be supporting reports submitted to the court. So that will include reports by two medical practitioners. One is usually a GP and one is a specialist consultant. And there also has to be provided a report by a mental health officer, which looks at the appropriateness of guardianship and the suitability of the nominated guardian or guardians. So once that's received at court, the incapable person and other interested parties are sent out a copy of the application. And at a subsequent hearing, if there's no opposition and the sheriff's happy with the appropriateness of guardianship and the suitability of the guardian, the order will be granted. Another main difference between a power of attorney and a guardianship order is that the incapable person does not elect who they would wish to act for them, and that's a decision that's actually taken by the court. Whereas a power of attorney puts you in control of that, who you pick and what powers they have. Another point to note is that financial guardians are subject to supervision by the Office of the Public Guardian, and welfare guardians are supervised to a certain extent by local authorities. So for all sorts of reasons, I would always suggest that having a power of attorney in place is a good and sensible thing to have. You're in control and your own wishes and feelings are very much reflected in that decision. Only having a power of attorney gives you the opportunity, while you're capable, to set out exactly what you would want to happen at some point in the future when you may no longer have capacity. While there are other options, take the simple one, do your power of attorney. And I can actually reflect back to a number of years ago when there was a young woman who gave birth to her second child, and in the hours after giving birth she became unwell, and to the extent that she suffered from a brain injury. At what should have been a fantastic and a point of life of celebration, suddenly her husband was in the position of having to make really important decisions for her, especially when she was in a position to move into a more suitable care setting. There wasn't a power of attorney in place, so there was a big long delay until a guardianship order could be obtained. So this lady actually stayed in an inappropriate NHS setting for far longer than might have been necessary. Had a power of attorney been in place, decisions about where she should live and what her care should be could have been made much sooner, and she wouldn't have stayed in hospital so long. So my advice to anyone listening is, please don't put off granting your own power of attorney or starting that important conversation. It's better to do it now than to have regrets in the future when it's too late and you're no longer capable, or your loved one isn't capable of making a power of attorney. It could prevent delay, and you'd be in a position to act sooner rather than later.